Morning, and welcome to the appeal by Scott Mankey of hearing examiner's reconsideration decision denying a reasonable use exception and a shoreline conditional use permit for proposed new and existing non-permitted developments. I am Commissioner Hutchings and will be presiding over today's appeal. I have Commissioner Gary Edwards and Commissioner Menser joining us as well. Today's date is July 9, 2020. And it's 8:32 in the morning. The Thurston County Board of Commissioners is now on the record in an appeal filed by Scott Mankey of the hearing examiner's reconsideration decision dated May 18, 2020. This decision denied Mr. Mankey's request for, number one, a reasonable use exception to add 1,100 square foot addition to an existing single-family residence and maintain a 784 square foot detached home office previously constructed without permits, all within shoreline, landslide hazard, and wetland buffers. And two, a shoreline conditional use permit for retaining walls within a conservancy shoreline previously constructed without permits. Before a reasonable use exemption can be approved for an expansion to Mr. Mankey's residence and the permission to maintain his unpermitted home office, Mr. Mankey must demonstrate that without these improvements, no other reasonable use of the property is permitted by the county code. That's Thurston County Code 24.45.030. The hearing examiner determined that Mr. Mankey's property already enjoyed reasonable use of his property as a result of the legally non-conforming residence, and therefore did not meet the Thurston County Code criteria to expand his residence nor keep the unpermitted home office. Before a shoreline conditional use permit may be approved for Mr. Mankey's existing retaining wall, there cannot be any other shoreline violations on his property. Thurston County Code 19.14.010. While the hearing examiner acknowledged that with conditions officially permitting the existing retaining wall would result in no detrimental effect to the public interest, she was constrained by the Shoreline Master Program regulations, which prohibit approval if there are other violations on site. In this case, she found that there are structures on site that constitute violations, and no shoreline permit can be granted until such violations are resolved in some manner. The applicant challenges the hearing examiner's decision, arguing that, number one, the examiner created a presumption that the use on the property when it was purchased in the 1990s remained compelling evidence as to the reasonable use of the property now. And two, the examiner failed to consider that many of the improvements were made earlier than the present day, suggesting they were then considered by the owners to be necessary for a reasonable use on the property. And three, the examiner's overarching error was a failure to consider the overall reasonableness of the proposal, including minimizing impacts and mitigation that enhanced environmental values. And four, the examiner's denial of the retaining wall was error because if the examiner approved the reasonable use exemptions, the other violations would be cured. The issues before the Board of County Commissioners today are one, whether the existing single-family residence is a reasonable use of the property, and two, whether the other shoreline violations on the property prevent approval of the retaining wall, which can meet all code requirements. So this is regarding the appearance of fairness declarations. In quasi-judicial appeals, the board is subject to the appearance of fairness doctrine, codified in Chapter 42.36 of the RCW. Under this doctrine, the board members are not authorized to have ex parte communications with the parties after an appeal has been filed with the board. However, if there have been ex parte communications since the appeal was filed, or communication or relationships with any of the parties that may appear to impact their impartiality, then the substance of that communication or relationship needs to be disclosed. In addition, each board member must be able to impartially judge this case on the facts contained in the record and the applicable law. At this time, I will ask each commissioner to make a declaration for the record. The appeal was filed on May 29th, 2020, and I will begin. As for Commissioner Hutchings, myself, I have had ex parte communication with Mr. Mankey about this case for the limited purposes of a site visit. I was accompanied by Elizabeth Petrich, our deputy prosecuting attorney. This was on July 6th, 2020. Mr. Mankey showed us the property and the approximate locations of the proposed development and critical areas. There was no other discussion other than what is represented in the record. The site visit lasted about 30 minutes. However, despite this interaction, I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law. I have not had any other ex parte communication with any of the parties in this appeal, and I affirm that I can fairly... Oh, okay, that's for... now I'll turn to Mr. Commissioner Messer for your declaration.
Yes, I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law.
Commissioner Edwards?
Looking around the room, I don't know who's associated with this appeal or not, and I can't recognize anybody due to the mask. So I don't know who's in the room that I may or may not know. But I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law. And the only thing wrong with that would be if somebody stepped forward and said, well, I talked to you last week, don't you remember? Well, I can't recognize you right now. So other than that, I have had, I'm not saying I've talked to you last week, but I want you to know that this causes a bit of an inconvenience on recognizing folks in the community. But I've had no information about this whatsoever.
Do any of the parties have any objections or challenges for any board member to decide this case? Nobody? I'm not seeing anybody. No hands going up? Nothing. Okay. So now we're going into oral arguments by the parties. The applicant has an opportunity to present 15 minutes of oral argument. Oral argument may not represent new information or evidence, but must be limited to the evidence already in the record and the specific issues raised in the applicant's appeal. I understand the department will not be presenting oral argument, but is available to questions from the board. The board, if it has any questions, will ask them of the parties during or after argument. Do any of the parties have any questions before we begin argument? No, okay. Then we will set a timer here, approximately 15 minutes. What I would caution, though, because I just said that the board, if we have any questions, can ask them of the parties during or after argument. Should a question last 3 or 4 minutes, I don't want that to count against the appellant. So we'll kind of keep track of that. Thank you, sir.
Good morning, Commissioners. My name is William Lynn. I'm here on behalf of the Mankey family, Scott and Terry, who are sitting in the front row. I appreciate your being willing to conduct this hearing live. It has not been my recent experience in other jurisdictions, so it's nice to see faces and not little pictures on screens. The Mankeys built their home, as you've indicated, in the early 1990s. It's a 5-acre site. I call it that. Actually, 2.5 acres approximately are upland, 2.5 acres are tideland. So if I call it a 5-acre site, I'm not trying to misrepresent things. That's just how I know it. And as you've indicated, our primary contention here today is that what's reasonable involves, it creates an opportunity to look beyond the code and into what you interpret to be reasonable. And that can take into account and should take into account the size of the property, the value of the property, the location of the property, and most importantly, in this case, it shouldn't be fixed by what happened 30 years ago when the Mankeys built their home. That was not the ultimate reasonable use of the property. It's what they did at the time, and it shouldn't have been determinative as it was for the examiner in this case. So the Mankeys did build their home in the early 1990s. That was fully permitted. They shortly after that built a garage and the stairs. So and then later on, they built the retaining wall because there was a need for that. And then more recently, they built the home office. These things happened over time. They should have obtained permits for that. They acknowledge that. Frankly, from my perspective, it probably would have been much easier to permit things at the time had they gone through that process, but they didn't. What's important, though, is that these improvements were not deemed by them to ruin the bucolic setting they had on their lovely property. They were things that they thought they needed to reasonably use their property. They had no objections from neighbors. They had no objections from the county. And by all accounts, or from all reckoning anyway, these were things that served them and enhanced their use and enjoyment of the property. I need to talk about the process below a little bit because I think it might put some things in context. At some point in the last couple of years, the Mankeys decided they wanted to build an addition to their home. Not a huge one. It's about 1,100 square feet. It's kind of hard, as you might have looked at the record here, it's a little hard to figure out what numbers are appropriate. They vary because in certain improvements count for some purposes and not other purposes. But just for our conversation today, the house is about 3,000 square feet, and they proposed about a 1,000-foot addition. The staff, when they came in,
Keep going, sir, keep going.
the staff, when they came in, noted these different requirements: the riparian zones and setbacks, the wetlands and setbacks, the geotechnical issues, and those were all very limiting in terms of where they could build on the property, and that's what leads us here today. The staff also advised them that they would need to go back through the permitting process for these improvements that were built without permits. And it's kind of ironic that the same things that drew them to this property that made living here attractive are also the things that are highly regulated. So the Mankeys engaged an engineering firm. They engaged a biologist and a geotechnical engineer. They submitted all the reports the county wanted, and the county accepted all of those reports. They were surprised, to say the least, when they received the staff report for the pending hearing in front of the examiner and found that the staff was recommending just no across the board. There were no conditions, there were no compromises, there were no mitigation measures identified. It was just a no, which frankly left them scurrying a little bit at the time of the first hearing. And the hearing examiner denied the project. We asked for reconsideration, and at that point really tried to engage the staff in some conversation about what could be done here to allow this, the use of this property. And we really, let's just say it didn't result in any solid communications. So we asked the hearing examiner to reopen the hearing and to let us present some evidence on a compromise potentially and some mitigation. And so the Mankeys went, and although they didn't know what they were arguing against exactly, they revised their proposal to eliminate the stairs, to eliminate the driveway and the part of the driveway apron and the garage and the shed. And so they greatly limited their proposal. I think the examiner found it was a substantial improvement. They also offered a mitigation plan that mitigated the impacts at a 3-to-1 ratio. Only a 1-to-1 ratio would be required. They proposed to plant 550 plants, of which 160 would be trees. So they very substantially altered their proposal. Wasn't what they wanted to do, but it was what they were doing in an effort to try to obtain staff approval and then ultimately the hearing examiner's approval. The hearing examiner noted the improvements. She noted that the mitigation was such that there would be no net loss of habitat and potentially even a lift, an improvement in biological conditions. She noted that the opportunities to develop elsewhere on the property were extremely limited, but she still denied the reasonable use exception, really on the basis that because the Mankeys had built this particular home in 1992, that was a reasonable use. And if it was a reasonable use in 1992, it's a reasonable use now. We don't think that the reasonable use exception is so narrowly interpreted. We think that it creates an opportunity for the Mankeys to demonstrate and for you and the examiner to consider other elements that go into making a use a reasonable one. Well, let me just address this fixing in 1990. When you build a house or buy a house, that's not necessarily your dream home. Your budget may constrain you, your family size may constrain you. You may have all kinds of grand plans, and those aren't unreasonable. You didn't necessarily tie yourself to the original design when you built the house. So budget, family size, and other factors limit or make available, in our view, a different reasonable use over time. I'd like to talk a little bit about the passage of time, because things change over time, not just your budget and your family, but technology. I mean, how many of us in this room would have thought it was as important to have a home office today, even 6 months ago? How many homes have parlors anymore, or, you know, they're a thing of the past, and yet a TV room or a great room or a bonus room, it becomes important. People's needs change over time as technology changes, as the market changes, as the way in which we use and enjoy our homes change. That's just a fact of life, and it's just wrong to try to fix things as of 1990. The location is also important. We all know what has happened to the values of waterfront property in the last 30 years. It has skyrocketed. So what might have been a reasonable use of waterfront property in the 1990s could have been a cabin or a cottage. But drive around the waterfront now and see how many of those you see. You see a lot more permanent homes, a lot more substantial improvements. The Mankey proposal is not a McMansion by any means. It's a reasonable use, in our view, of this prime location. I think the waterfront location is important in another sense, in that waterfront homes become a magnet. Oftentimes in a waterfront home, you're not just accommodating your immediate family, but your grandchildren and your friends and your families, because as the Shoreline Management Act anticipates, we want people to use and enjoy the waterfront, and they necessarily accommodate more people. They need some flexibility in the space, and I think that's another factor that goes into what's reasonable, as is the fact that on the waterfront you have different needs. You have kids and kayaks and paddle boards and paddles and life jackets and outdoor furniture and umbrellas. You need more storage. In a community or a climate like ours, you have all kinds of things that go out in the summer and back into the winter. You need storage space. So these are all reasonable and normal things. I don't think the Mankeys are asking for anything extraordinary. They just want to be able to use and enjoy their property. And then finally, I think you have to consider the size of the property. There are lots of 5,000 and 10,000 square foot waterfront lots where you're lucky to have a house at all with the limitations, any kind of a little cabin or house. This is 5 acres, 2.5 acres upland. It's a very substantial property, and so what's reasonable here is not necessarily what is reasonable elsewhere. You need to look at the property. 205,000 square feet of property and about 4,000 square feet of the home. So we think you have to look at this in context. And when you do, we think the examiner unnecessarily confined herself by looking at what was there in 1992, and instead should have taken a broader view. And had she done that, we think that these modest additions, a home office and a 1,000-foot of addition of part of which is over a garage and part of which is over a deck, should be considered a reasonable use, particularly in light of this very substantial reasonable use, or I'm sorry, the mitigation plan that was submitted. That's all I have. As you've noted in your preliminary comments, the retaining wall is by all recognized as a good thing. It actually protects water quality. I think she would love to have been able to approve it. She felt constrained by the reasonable use decision, so she wasn't able to. So we're asking that that decision be reversed and that both approvals be granted.
All right, thank you, sir. Is there anybody else who will be speaking?
No, unless Mr. Mankey or Mrs. Mankey wants to say anything, but I think that's it from us, unless you.
I'll turn to my seatmates. Do you have any questions? Mr. Lynn? Do you?
I do have a question.
Certainly.
Don't know how relevant it is, but I think it's relevant for the record. How much have the Mankeys put out in dollars to get to the point we are today in front of this board?
I couldn't tell you.
Can you give me a rough estimate?
Probably $80,000 to $100,000.
Is that including attorney's fees?
Yes.
Okay.
And
Going on 3 years.
do you know, does the current law allow you to recoup your expenses if you prevail in this hearing from the county?
I don't believe so. That would be, it would be a very unusual provision if it allowed that. Sometimes you get a filing fee refunded, but typically those are nominal.
Okay.
Commissioner Messer?
Yes. Sir. One question I had was, there was a discussion, and I'm going to apologize in advance. I looked at paperwork and I listened to your previous proceedings, so if I'm quoting something, I'm not sure exactly where it's from. But there's something, there was a discussion about one of the criterion that talked about the alternative locations for accessory structures. You made the point in the oral hearing, I believe, that the alternative location would still be within a buffer. And then as I read the hearing examiner's decision, it sounded like she was saying that, well, yeah, but it would be further back in the buffer, and as if location within the buffer mattered. And so I wondered what your response was to that, because it wasn't clear to me if you disputed that or not.
Okay. The only area, and I think there was agreement about this, there was a small area at the back corner of the house, kind of an odd shape, where you could actually build outside the buffer. You still would need the reasonable use exception, but it also, but it wasn't big and it wasn't well located. It wasn't suitable for an addition to the house of the type they were doing. I mean, for example, the kitchen addition goes out over an existing deck. It needs to be adjacent to the deck, I mean, adjacent to the existing condition to actually accommodate what its purpose. So having something on the back corner of the house wouldn't really serve that purpose. I think that may be. And in terms of whether or not being at a different place in the buffer matters, I don't think there's any evidence that it would materially matter. You're talking about one side of the house versus the back corner of the house. I don't think there's anything to suggest that that would be material.
Another question I had was the reasonable use criteria. There's the 8 criteria.
Right.
I'm sure you're familiar with that. And when I look at today, both today and in your previous presentations, you talk about, we think this is a reasonable use of the property
Right.
that the family's engaged in, and I don't think I would dispute that. But looking at B, for example, no reasonable use with less impact is possible. Doesn't that suggest that it's not about any reasonable use, but that there's a range of reasonable uses, and to satisfy this criteria, you need the particular reasonable use with the least impact on the critical area?
Yeah,
I'm struggling with that.
It's a challenging requirement. I deal with these in different jurisdictions. This one this is a challenging test. I will concede that. On the other hand, the use of the term reasonable, I think, opens it up to different sorts of uses. And you could have any number of ways in which living could be accommodated on this property. Maybe you could build a tall house in the middle to accommodate these different needs of a homeowner, or in this case, you start with what you had to begin with. And so it's really kind of what's reasonable in the context of that. I don't read this to be so inflexible to say that the Mankeys have to live in the footprint they chose in 1992 under a different set of regulations, and that they're forever wedded to that. I don't think that's what was intended by this. If you look at the array of different standards here, you know, the term reasonable use is used a number of times, and I forgot to mention earlier that one of the things I mentioned in my argument below is that a home business is actually permitted on this site. Having a home office, I think, is fully consistent with the allowed uses on the property. I think it's a reasonable use. I'm not sure I've answered your question, but it's.
One thing I heard, I think a county staff member say in the October proceeding was, I wrote the quote down. She said, "Code is clear that a larger than average home and a larger than average garage constitute a reasonable use on a residential parcel." I couldn't find that provision in the, is that true, or do you dispute that, or where's she getting that?
I mean, is that somehow allowed outright without going through this process?
Well, whether it's implied or explicit, you know, I didn't find in the provisions that were in the different, you know, there's some legal standards laid out in the hearing examiner's materials. I didn't find in my written materials, and I can ask the county attorney maybe this question as well. I just wanted to give you a chance to say that that was false or true. Is there anything in Thurston County Code that you're aware of that would suggest that a larger than average home is a reasonable use, period, regardless of the needs of the family?
Oh.
The fact that they've got kids and may have kayaks or whatever.
Yeah, I mean, I don't think there's going to be something in code that says that, but to me, that's inherent in the term reasonable, that reasonable is not one thing on all lots. It's not one thing on all, for all families. It can be a variety of things. I think it's intended to open the door for a fair discussion about what's reasonable on a piece of property. And again, when you look at all the factors here, the size and the location and the value of the property. And, you know, in this page, there's something else that I think is kind of meaningful here. It's not directly related to this property, but the Mankeys own adjacent property that's also part of this overall complex. It's a very unusual circumstance. So the openness around this property is sort of exponentially increased by the other land that they own around it. That's part of the context. Again, it doesn't really relate to this property in a direct way, but I think it contributes to the overall feeling out there, which is, and it's too bad we don't have a better visual for you, but I don't think when you go out there, you get the sense that this is overdeveloped in any way at all.
I'll hit you with one more, and then I'll let you go. I just wanted to nail down this concept of the mitigation, because as I read the 8 criteria, you know, they're all and, right? You got to have them all. And it talks about F, I guess it is, that says there shall be the proposal for RUE shall ensure no net loss of critical area functions and values. The proposal shall include a mitigation plan. So that's one of the things that has to kind of be in there. I just want to make sure you're not contending that there can be sort of a trade. I mean, it sounded like in the hearing I think at the reconsideration hearing, that because that's where you came forward with your kind of scaled back proposal and mitigation 3-for-1 and caught all that.
Right.
And the types of vegetation was discussed. But you're not saying that if you mitigate enough, it can offset the violations, because I don't see that in this
And I agree. I mean, just strictly speaking, there's a mitigation requirement and there's the reasonable use provisions. They're two different numbered paragraphs. But before I forget, Kathy Hargrave, who's the engineer, wanted to remind me that none of these improvements are actually in the critical areas. They're all in buffers and they all can be mitigated under county code. But getting back to your point, if all we were doing was the bare minimum of mitigation, the 1-to-1, I would agree. When we go above and beyond that, I think that does, that's part of what's reasonable. It's part of, I think if you asked a person on the street, should we allow somebody to do a little more building on a property if they restore an area that's important to the habitat in a way that goes above and beyond what the code requires, should that be taken into account? I would say, yeah. Should it be the overwhelming factor? Probably not. If it were otherwise an unreasonable use, I wouldn't argue that. But here, taking into account everything else, the fact that they went above and beyond with this mitigation plan and gave up improvements that they built and expected to be able to use for their useful lives, I think are factors that go into determining what's reasonable.
Thanks, sir.
Oh, don't go away. I haven't had my shot at you.
Sorry.
Thank you. This, Mr. Lynn, this apparently is 3 years worth and about $100,000 worth of.
I don't think you have the whole package.
No, I'm sure I don't. And this was quite a bit to chew through over several days. My question is this: I read in my opening remarks, and I'll go right to my opening remarks. The hearings examiner acknowledged with conditions officially permitting the existing retaining wall would result in no detrimental effect to the public interest, and she was constrained by the Shoreline Master Program regulations, which prohibit approval if there are other violations on site.
Right.
So my question is regarding like mitigation, if, and this is just per you, if the retaining wall, that outbuilding, and the garage that's furthest away from the home, if they were removed, does that remove the violations?
No, because you'd also have to remove the home office.
Oh, the home office, how about then the stairwell? The stairwell's coming out anyway. That's,
Stairwell's coming out, but yeah, basically, her issue of compliance with codes goes away if the reasonable use exception is granted, because those things can all become permitted if the reasonable use exception is granted, or if all those improvements are removed, either way.
okay. And was there any, notice was sent out to all property owners within 500 feet? Did anybody object?
The only person who was present was somebody who supported the proposal, and I think there were letters in there from the owners of the Zittles Marina, which is nearby. They may live nearby too. They also supported the proposal. There was no opposition to it I was ever aware of.
And without going into, back into digging into this, do you know about how many property owners are within 500 feet?
Just a couple. I think it's.
I own the property all around.
Oh, okay.
And the family owns the estuary up there, so.
Okay,
Yeah.
all right. All right, thank you, sir, that's all I have. Any other questions?
I do have one question for the board, I guess, and that is, are we going to be prepared to make a decision this morning?
No. Hey, I wanted to say that. No.
Well, I disagree with that, but that I'm a minority in that position then, I would guess.
Okay. Thank you, sir, Mr. Lynn, thank you very much.
Yes, I do have a statement.
Oh, sure, go ahead.
We ask questions of,
We have questions of
Travis?
staff? Yeah.
before we go to.
No, go ahead.
We go right
Go
into
ahead.
questions of Travis or Elizabeth, whichever. Go right ahead when you're ready.
Is it Travis or is it Elizabeth?
That depends on the kind of question.
Oh, they're both representing, oh, okay. My question is just, I wanted to give you the opportunity to address the issue that I raised with Mr. Lynn, which is that in the, I believe it was the October 22nd proceeding, a representative from Thurston County said, and I quote, "Code is clear that a larger than average home and a larger than average garage constitute a reasonable use on a residential parcel." Is that true? And where is code clear? I didn't see any code that laid that out or even implied that. So is there a basis for that statement of the county employee?
Elizabeth Petrich, Deputy Prosecuting Attorney representing the board in this appeal. I am not aware of any code provision that says that. I would defer to ask Travis to add, if he has a perspective on that. He works more closely with the code on a day-to-day basis with staff. So I'd like to ask Travis if he has any response to that question.
Yeah,
Travis?
hi, Travis Burns, prosecuting attorney's office. I am, when that came up earlier, I took a quick look. I'm not, I wasn't present at the hearing, and so I can't attest to what, the representative may have been thinking. But offhand, I would agree with Elizabeth. I'm not aware of a specific provision in code that defines that type of use as presumptively reasonable. Again, it's just the criteria under the code that you all are evaluating and that the hearing examiner evaluated with the 8 criteria, A through, whatever number or letter that was. So that doesn't mean there wasn't, in fact, another provision that staff are relying on, but I don't offhand know of a presumptive categorical, definition in the code that does really answer the question in front of you.
Thank you.
Did it?
Yep.
Okay. And subsequent to this, we're going to issue our decision on or before July 29th. I'll get to you. Before July 29th, we may or may not have an executive session associated with that. Okay. Commissioner Edwards?
I guess I would ask this of the county manager. Are we in an official session as the Board of County Commissioners?
Today,
Right now?
This is a specific hearing for the matter before you.
Yes. But are we in session right now? So could a motion be made?
That is specific item is in the CPR from the items presented to you. So it's not about a motion, it's about a decision that you make with the board.
Okay, well, I'm going to point something out in my statement. I've reviewed this. I've heard testimony. I believe that the Mankeys are victims of legal extortion by the government. And I would make a motion to rule on this today while we are sitting here in front of the public as completely transparent as we can possibly be. So if I get a second, we'll move forward,
No
and if we
second to that
don't, I
motion?
won't.
Nope. Okay. Dies for lack of a second. And as I said, we will have an executive session regarding this coming up shortly or soon, and a written decision will be made, and it will be made public, as transparent as can be as well. It will be made, and
Sir,
the world.
I have a question,
I have
sir.
the floor,
I know.
Thank
but I
you.
want to make sure you recognize
And-
me before you end this thing.
and it will be as transparent as possible, and everybody will know whether Mr. Mankey has granted the reasonable use exception or not. Do you have any question or comments before I go back to Commissioner Edwards? Go ahead.
I would like to know why we're going to be required to go into a secret executive session. I'd like to have that explained to me by counsel.
Counsel, go ahead, Elizabeth.
Technically, this type of proceeding, you are currently in a quasi-judicial proceeding where you are hearing and deciding the case between particular parties. Under the Open Public Meetings Act, the quasi-judicial proceedings are exempted from the requirement of having a public open meeting. So there is no executive session. This whole process is exempt from the requirements of the Open Public Meeting. So I just wanted to clarify, that's a little bit technical, but the purpose of allowing the board to meet outside of the requirements of the Open Public Meeting is so that you can ask questions about the legal criteria, whether the facts comply with the criteria or not, so that you can discuss that together. And you have that right. Do you have to take that right? No, but you certainly have that right to discuss that privately.
One comment made by counsel I'd like for clarification. You said particular parties. Who are the other parties involved in this, if not the Mankeys?
In this case, it is just the applicant and the planning department.
Okay. Just then a statement for the record that I am adamantly opposed to any secret meetings conducted by this board on this topic that's commonly referred to as an executive session. I'm done, sir.
Okay. And you'll be invited, but it's not required you attend.
Yes, sir.
And I just wanted to be clear for the record as well, my reluctance to decide right now is not intended in any way, shape, or form to show any bias for or against the applicant. I just want to be exceptionally diligent in my duty in understanding this completely before I decide to make a decision based on emotion. Thank you. With that, as I said, I want to thank everybody for coming and attending and masking up. And the board will issue their written decision on or before July 29, 2020. And this hearing is over.
Thank you.